Recording.
All right, thank you. Good afternoon again, everyone. The appellate court for the state of Connecticut is back in session. We will now hear the matter of COCCHIA versus TESTA AC 44026. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Cradle and Judge Clark. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearances, for the record, let me alert or otherwise remind everyone that this argument is being live streamed on the Judicial Branch's YouTube channel. Accordingly, to the extent this case involves any protected identifying information that should not be disclosed, counsel are reminded not to disclose such information during arguments. I would now ask that everyone participating in this hearing identify themselves, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall. I'm Judge Cradle.
Good afternoon, Judge Clark.
Good afternoon, Your Honors. Christopher D. Height on behalf of the appellant, Robert J. Testa Jr. as trustee for the Karen M. Testa Separate Property Trust.
Good afternoon, Your Honors. Todd Michaelis of Cormier, Torrance, Sandak, and Hennessy on behalf of the appellee, Francis A. COCCHIA.
All right, thank you. Counsel, prior to this argument, you should have received procedural instructions. Do you have any questions regarding those instructions?
No, Your Honor.
No questions, Your Honor.
All right, a few additional preliminaries. When you are not speaking, if you would kindly ensure that your video is left on while muting your audio. We have found that as many people as is possible, when they mute their audio, it does help avoiding that feedback that we've become familiar with. Also, let me state the obvious, and I'm sure this will not be an issue, but during this proceeding, kindly conduct yourselves as though you were in the physical courtroom so as not to create any distractions for the judges or opposing counsel. Each side will be permitted 20 minutes of argument. If the appellant wishes to reserve a portion of the 20 minutes for rebuttal, kindly let me know when you begin. I will endeavor to give you a 2-minute and 1-minute warning. So, counsel for the appellant, are you ready to proceed?
Yes, Your Honor.
All right, you may do so.
Thank you, Your Honor. To please the court, counsel would like to reserve 5 minutes potentially for rebuttal.
All right, that's fine. Go ahead.
Okay, Your Honor. May it please the court, my name is Christopher Height. I represent the appellate, Robert J. Testa Jr. as trustee for the Karen M. Testa Separate Property Trust in this matter. Your Honor, in the appellant's view, this is, although the facts that got both the trial court and the appellate court to this point are kind of an unusual factual pattern and series of events that got us here, the appellate contends this is a straightforward procedural issue and that the trial court erred in denying the defendant's motion to dismiss for lack of personal jurisdiction simply because the trial court never properly had personal jurisdiction over defendant Robert J. Testa Jr. as trustee for the Karen M. Testa Separate Property Trust. If it's okay with Your Honors, going forward, to make that easier for the court, in less just needlessly wordy, I would like to refer to my client as simply the Testa Trust for simplification. Your Honor, it really goes to the crux of the issue is this. This was a case commenced in 2016. It is a collection of a commercial promissory note between the parties. The original defendant, Robert J. Testa, was the guarantor and maker of that promissory note to the plaintiff. The case went on procedurally. There was a lot of motion practice initially in the case. There were some requests to revise and some other technical issues. And then at a certain point, the parties all became aware that my original client, Mr. Testa Sr., had passed away. Everyone involved was aware of this. It was been my understanding in this case that all the parties involved in this case have known each other for many years, and in fact, the appellee and the plaintiff were friends with the appellant defendant prior to his passing. So they were aware of the passing. And at the time, parties alerted the court. This was sometime in 2017. It is what procedurally happened after that is when this case took some very unusual procedural turns, Your Honor, that led to the actions that ultimately led to both the defendant's motion to dismiss, motion to open, and ultimately the appeal that is before the court today. And it simply comes down to this issue, Your Honor. Once Mr. Testa had passed, the plaintiff did not narrowly seek an estate substitution pursuant to CGS 52-599 to substitute the estate of Mr. Testa in the shoes of Mr. Testa for purpose of proceeding with the counts. First, there was a revised complaint was filed, I believe, Your Honor, and it simply communicated the plaintiff's wishes to potentially add the Testa trust by revised complaint, but it didn't go any further. That motion sat on the docket for potentially a year, which was seemingly not acted on. So another year.
Attorney Height, let me interrupt you with a question. So you're referring to the February 2018 request to amend that was filed by the plaintiff?
Let me see here, Your Honor. Yes, I'm believing, yes, February 6, 2018.
So you just said that it sat on the docket and it wasn't ruled on, but because it was a request that went unobjected to, it didn't require a ruling, correct?
For that narrow purpose, yes, Your Honor, that is correct, which I got.
And you didn't file an objection, which would have required a ruling.
Yes, Your Honor. I would note that with regard to that, at that time, Mr. Testa had passed. The plaintiff had not moved to substitute the estate and as a party. I would represent, and this is my position now as it was then, that at the time that I essentially didn't have a client at the time, I wouldn't have had standing to file an objection to that. Although I don't believe that goes to the ultimate issue as this further develops, or it is my position that we wouldn't have had standing to object to that as a party.
All right, but you didn't move to withdraw or anything like that?
No, Your Honor, no.
All right, and let me ask you a question. So by the time, or at the time you begin to represent Mr. Testa Jr. as the trustee on behalf of the trust, what evidence was put before the trial court, evidence, so not representations by counsel, but what evidence was put before the trial court that Mr. Testa Jr. did not, in fact, get served with a copy of the March 2019 amended complaint?
There is none, Your Honor, which is one of the reasons that counsel believes that there was both a motion to open filed as well as the motion to dismiss. And it was counsel's position, as it's the appellant's position, that an appeal of the motion to open wouldn't have, because of the factors it requires, given the notice, the excusable delay, and the defense going into the merits, the original suit, that wouldn't have been meritorious to appeal, and that was not appealed, Your Honor. The problem lies not in the specific service itself as the return is offered. The problem lies in that he was never made a party by authority of the court. The plaintiff had never filed a motion to cite party defendant, which is necessary under CGS 52-102, 107, 108, which is the only way under these circumstances that the plaintiff could have added a new party with new counts and causes of action in this action. It is the procedure in place. It is the only procedure in place. It has to be narrowly and strictly followed, Your Honor. A motion to cite party defendant needs to be filed. It needs to comply with the requirements of practice book 9-22.
So, well, let me interrupt you again. I'm sorry.
No
So
problem.
when Judge Kavaniewski granted the motion to substitute, is it your position that that ruling is simply a nullity?
Yes, Your Honor. Yes, it is. My position is that ruling had no effect. A plaintiff cannot have a party defendant substituted in for another party. The only exception to that is the narrow exception of a motion to substitute defendant that would narrowly substitute in the fiduciary as executor of estate of a deceased person pursuant to CGS 52-599. That is very statutorily narrow, Your Honor. That cannot add new counts, that cannot add new parties. That takes the same cause of action and merely prevents the suit from being defeated because a person's deceased. It takes that, it transfers it from deceased individual to executor of estate of deceased individual, and that action continues. What was necessary here was a motion to cite party defendant. It's regular practice in the Superior Court to do so, and it's necessary anytime a new party is going to be added, also with new facts giving rise and new causes of action. This is routinely done in the Superior Court. There's even a form order for it in the practice book. Practice book form 106.4 is a form order that addresses this exact situation. And in filing a motion to cite party defendant, Your Honor, the moving party has to ask for specific findings to be made in an order pursuant to CGS 52-107 and 108, which is in most parties' motions, and it creates a form order. And this is something that doesn't happen a great deal in civil practice, but its most common application is likely in the instance of foreclosure, where a plaintiff will foreclose on a party who's an owner of a property. Either subsequently, the owner of the property will pass away, or the plaintiff will learn that the property owner had passed away, in which case a motion to substitute defendant is not sufficient because it's giving rise to new facts and new claims and new parties and interests. In that case, the plaintiff would have to file a motion to cite with a proposed form order that is laid out in practice book 106-4. And in that case, the court would issue a form order. And this happens in foreclosure cases regularly because they would have to allege in that some facts have changed. And because of that, it's necessary to join new parties. They would add the heirs of that individual and or the estate. They would also have to list the Connecticut Department of Revenue Services, get permission to add them as a party and allege facts that because the person passed away and the estate hasn't been probated, the state of Connecticut could have an inchoate lien for probate fees or estate tax due. That's why this procedure is in place. And it has to be followed, Your Honor. And I could show the court hundreds of orders from various judges in various judicial districts that all ruling on in various contexts, motion to cite additional party. They all bear that form language. They all require the plaintiff to show reason why those parties should be added. Every single one of these orders also says when they have to be served by, and this is important too, sets when they would have to have them served by, Your Honor, when the return date would be, setting a return date, and when return of that would be. In this case, the plaintiff didn't have court permission, didn't have an order, didn't seek those findings, arbitrarily picked a return date with an appended complaint that was not even put on, that is not even consistent with the motion to substitute.
Well, Attorney Haidt, let me ask you another question. So what if the pleading had been entitled motion to cite in, and Judge Kavaniewski had simply issued a postcard ruling that said granted, and there was no language that you typically see in an order granting a motion to cite in? Is it your position that the movant cannot pick a return date that otherwise complies with the statutes, that it has to wait for the trial court to set a new return date?
Yes, that is my position, Your Honor.
And based on what?
They can't, the plaintiff cannot arbitrarily pick these dates. They need authority and ability to do so. There is court authority and appellate authority that is, it's not quite in this circumstance. Procedurally, it's not exactly on par, but essentially where somebody attempted to substitute a party and took steps like this beyond the authority that they have to do so, that in order to complete this process, the plaintiff needs an order that sets those things forward from the court.
But on what authority do you rely for that proposition?
Your Honor, in that simply the plaintiff doesn't have, pursuant to statute, the plaintiff does not have authority to cite in another party until specifically granted it. That is why all the form orders have the language of 52-107-108. It can't be done, Your Honor.
Well, Attorney Height, let me ask you the question in a different way. Are you aware of any statute that expressly requires the trial court to be the one to set a return date upon a defendant being permitted to be cited in?
No, Your Honor.
All right.
However, I would to just on that wavelength, the motion to cite, and again, this is not specified in statute, but courts have treated the requirements of the motion to cite very specifically, and there are numerous Superior Court cases involving personal injury where a hybrid interpleader motion was filed with a motion to cite and it was denied. There was also cases where a motion to cite didn't state the facts or didn't have a brief and it was denied.
Counselor, you filed a notice of appeal, right?
Yes, Your Honor.
Somebody did. I don't know. You've only appealed the court's denial of the motion to dismiss, right?
Yes, Your Honor.
Okay, and the basis for the motion to dismiss really only went, I think, to the adequacy of the service of process and therefore personal jurisdiction, right?
No, Your Honor. It did go to personal jurisdiction, but not because of the service of process. It went to personal jurisdiction as that because the party was never properly cited in, the TESTA trust was never a party to the action, that's why the court didn't have personal jurisdiction, not the technical service itself.
But the motion to dismiss was filed, subsequent to the time the judgment was entered, right?
Yes, Your Honor.
And the motion to open and vacate the judgment was denied but not appealed, right?
That's correct, Your Honor. Okay. That was done deliberately because of what would have been the required showing for the motion to open would have required the true prong showing of the excusable delay and both the merit as to the underlying claim that is required in a motion. And it was the appellant's position that appeal would not have been likely meritorious based on what's required, as long as the heightened standard of review, whereas this has plenary review.
All right, Attorney Height, you'll have 5 minutes for rebuttal.
Thank you.
All right, Attorney Michaelis, you may proceed.
Thank you, Your Honor. So the appellant raises two issues with the decision on the motion to dismiss. The first that was addressed during oral argument was that the motion, which was somewhat inaccurately titled the motion to substitute, didn't comply with Connecticut General Statutes 52-599. And there's two reasons why that argument should be rejected by the court. The first is that it wasn't raised below. That was not a basis for the motion to dismiss, and it's being raised for the first time on appeal. The second reason is because the motion wasn't made pursuant to 52-599. The claim against the trustee was not the same claim as the claim against Mr. Testa, the decedent. The claim against the trustee was for fraudulent conveyance, whereas the claim against the trustee was for breach of contract. The second basis on which the appellant seeks reversal of the decision on the motion to dismiss has to do with this assertion that there was never a motion to cite in. And it's the appellee's position that that's actually correct. The motion was made pursuant to practice book section 9-18, which is merely a copy of Connecticut General Statutes 52-107. And it provides for the court, for a party to move to have a party added. And then 52-108 provides the court authority to summon in by order, it says that new parties may be added and summoned in by order of the court at any stage of the action as the court deems in the interest of justice.
So, Counselor, I'm sorry, but is it
As the court has noted.
Counselor?
Yes, Your Honor.
Is it your position that the original defendant, Robert Testa Sr., or his estate always remained a party and still are a party to the underlying case?
So when he died, he couldn't remain a party.
Maybe
and Noah's. Sorry, Your Honor. Didn't want to
your audio is not good. It keeps breaking up. Judge Mald, should he try maybe not using his video to see if that helps? I don't know, because it's...
Well, Attorney Michaelis, are you using some kind of device to help with your audio, like an earpiece?
No, this is just through my computer speaker. I was just working fine earlier to do it.
Yeah, it's really not good. You're very choppy. I don't know if there's a cell phone near your computer. If there is, maybe, move it away from that. Sometimes that causes interference.
Okay. The cell phone is now off. Is this better?
So far.
It seems to be. So go. I'll give you a little extra time. So go ahead.
Okay. Thank you.
So I'm sorry. Who once the motion to substitute, which is what it was entitled, was granted, who at that point were the defendants in the case?
At the time the motion to substitute was granted, the new defendant, the trustee, needed to be served, and he was. And after he was served and the complaint was returned, the trustee became defendant.
No.
Yeah, your audio, Attorney Michaelis, still breaks up. So I don't know if turning your video off would help. Probably not. I don't know if perhaps you can call in.
I'm not sure. I've never had this issue. I can try. I apologize. I will do that as fast as possible.
That's all right. Do you have a phone number where you can call in?
Yeah, yes, I do, Your Honor. I believe it's on the...
It should be in the email?
Invitation. Yes. So I will do that now.
All right. So if you log off, we'll simply suspend for a moment and wait for you to call in.
Okay. I should leave the video conference?
I think you're going to have to.
Okay. I will do that and I will call right in.
Okay. Thank you.
Thank you. Hello, this is Attorney Michaelis. Am I
All right,
audible?
Attorney Michaelis, we can hear you. Can you hear me?
I can, yes.
Okay. All right. So if you want to try starting with a response to Judge Clark's question, and hopefully this will take care of the audio problem.
Thank you, Your Honor. Yes, Justice Clark, I believe you asked who was the defendant at the time that the motion to cite in was granted.
Well,
and
no, at the time the motion to substitute was granted, subsequent to that, assuming that the trustee was actually served and that the return was sent back to the court. In other words, after the motion to substitute, which is what it was called, was granted and effectuated, who then remained parties in the case?
The trustee was the defendant at that point, because no estate was ever opened for Mr. Testa Sr.
Okay, so, all right, so in either case, whether it was a motion to cite in or a motion to substitute, what we were left with was one defendant and a subsequent motion for judgment on a fraudulent transfer claim, correct?
That's correct, Your Honor.
And the trustee was not substituted in, and he didn't stand in the shoes of the decedent. So, putting aside, service of process questions and notice, how does the court go forward with a fraudulent transfer case against only the transferee, where no judgment has been entered against the debtor? And how does the court go further than that and enter a judgment, not just to obviate the transfer, but a money judgment enters against the transferee and the amount of the unliquidated debt?
So my first response to your question, Your Honor, is that is not at issue on the appeal, in that wasn't a basis for any of the motions before the trial court. But to answer your question, the factual allegations contained in what remained as count 1 in the complaint against that were alleged initially against Mr. Testa were a part of the count for fraudulent conveyance. In other words, the factual allegation was that there was a breach of contract and that Mr. Testa owed money to the plaintiff under the promissory note, and that then when you get into the second part of that claim, that there was a fraudulent transfer that took place to escape payment of that liability. And so what the court found when it ruled on the claim after the hearing and damages was that because the defendant didn't appear, it admitted to the truth of all those allegations. And then with regard to the money judgment, the court can enter a money judgment against a fraudulent transferee in the amount of what ultimately was owed. There's different ways you can go about recovering in the fraudulent transfer. You can reverse the transfer and then take the asset, or the fraudulent transferee can be ordered to pay the amount of value that was transferred to them.
Okay, but with respect to the first question, who was there to actually litigate and defend against the judgment itself that there was in fact a debt owed? I know there had been, when Mr. Testa Sr. was still in the case and still alive, that was being litigated. There had been motions to default against him for failure to appear and plead, which were ultimately, eventually, not enter. So, I mean, when I read the case law around indispensable parties to fraudulent transfer claims, it's when there is no judgment yet entered against the actual debtor and the transferor that the courts generally do require both parties, because the transferee is not in a position to defend against the actual, the debt itself. And so, isn't that a problem? Didn't you need to get the state in, or someone there who had knowledge of or could have actually litigated the underlying debt?
In this case, Your Honor, we don't know if there would have been an issue or a problem with the trustee coming in to defend against the claim under the contract, because the trustee didn't appear. And ultimately what the court found was that all of the factual allegations that laid the factual predicate for the fraudulent transfer claim were established when the default entered, because the default operated as an admission by the trustee to all the allegations of the complaint.
But what basis, why would we think for a moment that the trustee of a trust that was simply the transferee of property would have any basis to dispute one way or another the underlying debt? Didn't you need to bring in someone who was a fiduciary for the estate of the actual debtor? I mean, why would we expect the transferee to plead anything other than insufficient knowledge? I mean, it's not as though you alleged anything else in your complaint that would have led us to believe that the trustee had was anything other than a stranger to the original transaction that would have led to the debt.
I agree with your premise, Your Honor, that it's possible that the trustee may have done that. But ultimately, we just don't know. There's nothing in the record with regard to that because of the fact that the trustee never appeared until after the judgment entered. And the basis for to get back to the basis of the appeal, it has to do only with this idea that there wasn't the correct process to add the trustee as a defendant. And that's premised on the idea that the trustee was added by way of an amended complaint, which isn't the case. The trustee was added with that motion, which was, again, titled Motion to Substitute, but brought pursuant to Practice Book 9-18. And the court granted that motion, and then the summons and complaint were served on the defendant and returned to court. And with regard to counsel's argument concerning the return date, it was not established randomly or arbitrarily. It was established pursuant to Connecticut general statutes, and there are three statutes that govern how the return date is to be established. Section 52-58 states when it can be, and that's basically any Tuesday. And then sections 52-46 and 52-46A govern how service is to be effectuated after you establish what the return date is. And service was made and the complaint was returned to court in accordance with those statutes. And
Counselor, I'm sorry, I have to back up again because my reading of the record below is that only the fraudulent transfer claim, which was count 2, was A, alleged against this defendant, and B, the only count that a judgment was entered against. So there was never a judgment. There was never a judgment entered against a debtor. There was never a judgment. There was never a judgment debtor. There still isn't a judgment debtor. And so how do we proceed with the fraudulent transfer claim? I mean, the idea that the trustee is defaulted as to count 1, which wasn't even asserted against him, I'm still struggling with it. And we end up with a single party in what really ought to be a 2-party count.
Your Honor, the first part of what was called the second count of the complaint re-alleged paragraphs 1 through 17 of the first count. So every factual allegation that appeared in the first count was a part of the fraudulent transfer claim against the trustee.
I mean, why not cite in other strangers and have them defaulted with respect to the allegations that have nothing to do with them? You could cite me in, for instance. I mean, I'm just trying to understand why we would take anything from a default against a person who on its face is a stranger to the transaction that would give rise to the underlying debt.
And Your Honor, I apologize if I'm not answering the question, but my response to that is that the allegations of the complaint alleged that there was an amount owed and that the property was transferred to escape payment of that amount. And all of those, the court found that all of those allegations were admitted by virtue of the default, and that therefore the transfer was indeed fraudulent. And then the court entered judgment in plaintiff's favor for the amount of what the defendant effectively admitted was the amount of the debt, which was less than the value of the property, I believe. So
I have a question. I'm sorry. I don't mean to interrupt. If Robert Testa did not die, okay, and he transferred the property to his wife or a third party, would your motion still be proper?
A motion to add the trustee as a defendant?
To substitute. Would that still have been a proper motion?
So, Your Honor, and this is why I say that the motion is unfortunately titled, because it didn't seek to do away with Robert Testa as a defendant. And it didn't cite to the statutes that pertain to an actual substitution of a defendant. It was brought pursuant to Practice Book Section 9-18. And so the effect of that motion, if Robert Testa had not died, would have been to simply add the trustee as a defendant, which is in fact what happened here. The reason why Robert Testa wasn't the defendant at the time of the hearing and damages was by virtue of the fact that he had passed away. So while there might be some critique on how that motion was titled, the substance of the motion would have been the same, and it would have had the same result.
Well, when a defendant dies, isn't it incumbent upon the plaintiff to ensure that the fiduciary at some point is substituted into the case so that you can, in fact, get a judgment against the appropriate party and ensure that you get a proper, proper liquidated debt? I'm still struggling with how you were able to, in the context of a fraudulent transfer count, liquidate that debt with only the transferee in the case.
Yes, Your Honor. Normally, you would expect to see a fiduciary appear or a state to be opened, and in this case, that did not happen, which is recited in the motion to substitute, the fact that no estate had been opened. And so what the plaintiff was left with was the ability to cite in the trustee as a defendant and proceed on the fraudulent transfer claim. Of course, I presume if an estate had been opened, that the plaintiff would have also filed a true motion to substitute the executive or other fiduciary of the estate in under the first count as well. But because there was no estate, that wasn't possible. And to Your Honor's point about, that it seems unusual that the claim against the fraudulent transferee proceeded without a defendant on the breach of contract claim alone. It's also unusual that no estate was opened. And given a choice between, sorry, Your Honor.
Go ahead, Counselor.
Oh, and so between those two things, I think the burden should rest with the state to open an estate, appoint a fiduciary, so that could actually happen, and that they shouldn't be allowed to somehow escape liability by doing nothing. The plaintiff did what they were able to do here, and they followed the procedural rules of, Connecticut's procedural rules, and got permission of the court.
All right, Attorney Michaelis, this is Judge Mall. So with respect to count one, if the plaintiff wasn't going to proceed with a damages claim against, Mr. Testa Sr. because he had passed and there was no estate that was opened, do you agree with me at least that a withdrawal of claim one should have occurred?
Your Honor, it may have been moot because of the fact that he had passed away. And even if the count one was withdrawn, the factual allegations of that count that were included in count two, so paragraphs 1 through 17 of the complaint, would have remained in count two. So again, from a substantive perspective, there wouldn't have been any difference.
Well, I mean, if you were teaching trial practice, wouldn't you agree that the proper thing to do would have been to file a withdrawal of the count one as to Mr. Testa Sr.?
Your Honor, I truly don't know if that would be proper or not in this situation. And
all right. All right, you have about 2 minutes left.
Thank you. So in conclusion, I think that this comes down to really just one thing. The appeal is premised on the idea that there was no appropriate motion practice to add the trustee as a defendant. And the only way that could be found to be true is if you only focus on the word substitute in the motion that effectuated the addition of the transferee as a defendant and ignore the substance of it, which the plaintiff argues should not be done. And that there were 3 Superior Court judges who were involved in this process, and all of them saw it to be in accord with Connecticut practice. Judge Kavanewski granted the motion to add the trustee, substitute the trustee. Judge Gennario conducted the hearing and damages after the default entered and issued the memorandum of decision. And then Judge Adams denied the plaintiff's motion to dismiss and opined that she found the procedure the plaintiff undertook to be appropriate. And so the plaintiff requests that the appeal, that the decision in the motion to dismiss be affirmed.
All right. Thank you, Counselor. All right. Attorney
Thank
Height,
you.
you have 5 minutes for rebuttal. And you're on mute.
Sorry, Your Honor. Just quickly in rebuttal, I just wanted to address a couple things. And I think the first is a question, Your Honor, that you had posed to the appellee. And it would be, if you were a trial practice professor, what would be the proper procedure here? And I'm happy to answer that question, Your Honor. Proper procedure that the plaintiff should have followed, and in fact had to follow, would be to file a motion under CGS 52-599 to substitute the estate for Mr. Testa. The appellee had suggested that whether there's an estate or not is not within the power of the creditor. In fact, that's not accurate. A creditor can involuntarily open a probate estate in Connecticut. And in fact, Your Honor, and I've litigated cases where I represent an individual in a breach of contract case that was sued. And subsequently, my client passed away, and the creditor filed an involuntary proceeding in the Norwalk Probate Court to create an involuntary probate, naming me as the executor, and it was granted. And the plaintiff proceeded in that fashion. So that's one thing that would have needed to be done. The second thing would have been to file a motion to cite party defendant, to get a proper order granting it with a return date, service instructions, serve that, return it, and then proceed against both parties. But to go back to Justice Clark's question about once the substitution went through, how many parties were there? And that's an interesting question. One could possibly argue none, Your Honor. What happened is, upon the granting of the motion to substitute, the clerk of the Stanford Trial Court unceremoniously removed my firm's appearance from the e-file noticing without warning, and Mr. Testa was removed. So not only did the trustee, Mr. Testa, not, there's questions about the service that, aren't really up here, but he was, my firm didn't continue to get any notices or notifications or anything on behalf of either party, at which point Attorney Pelletreau was able to just essentially proceed unopposed to get his default judgment. And why that's especially important is because all of the property of the separate property trust is located in Arizona, where trial counsel subsequently moved to try to domesticate the judgment. And Arizona will domesticate judgments based on a default in another state. And that's how this came to be. And that's why this appeal had to quickly be filed, asserting the information that was available and meritorious, and that was still timely to appeal. I don't have anything further unless Your Honors have other questions.
When were you removed from the case? I mean, presumably you saw the motion to substitute because it hadn't been granted yet. So, I mean, you're the counsel of record. You see a motion to substitute is filed. You don't respond to it. And then you're surprised that at some point you become removed and you're not getting notice for anything anymore?
To be honest, yes, Your Honor, that's not procedure in Superior Court. That's not what happens. That's not how I've been on both ends of motions to cite hundreds of times. I've never seen anything like that happen before. Frankly, perhaps I shouldn't be, but I was very surprised. This procedure is just arbitrary. It didn't follow the statutes, the practice book. I've never seen anything happen like this procedurally in a case I litigated, and I hope not to again.
I don't see any further questions. So, counsel, thank you for participating in this virtual hearing. Attorney McAllis, I'm sorry we had difficulty with your audio, but I think we got through it all right. So thank you again for participating. The court will take the matter under advisement, and we stand adjourned until tomorrow, April 8th at 9:30 a.m. Thank you.
Thank you.
Thank you,
Your Honors.
Thank you, Your Honors.
Thank you.